Well, thank you, Chairman Doyle, for organizing this hearing, and thanks to all of our witnesses for being here today. I'd like to talk about the issue of 230 in the context of this horrendous tragedy in Wisconsin a few years ago, in armslist.com, where a man walked into a salon where his wife was working and shot her dead in front of their daughter and killed 2 others in that salon, and then killed himself. And this is the type of horrific tragedy that's all too common in America today. But Dr. McSherry, you mentioned, I think you misspoke a little bit because you said that was all legal, but it wasn't, because 2 days before the shooting, there was a temporary restraining order issued against that man. He went online shopping on armslist.com 2 days after that TRO was issued, and the next day he commenced his murder spree. And what happened is, Arms List knows that they have domestic abusers shopping, they've got felons, they've got terrorists shopping for firearms, and yet they're allowed to proceed with this. Earlier this year, the Wisconsin Supreme Court ruled that Arms List is immune, even though they know that they are perpetuating illegal content and these kind of tragedies. They said, the Wisconsin Supreme Court ruled that Arms List is immune because of Section 230. They basically said it did not matter that Arms List actually knew or even intended that its website would facilitate illegal firearm sales to dangerous persons. Section 230 still granted immunity. And then, Ms. Peters, you've highlighted that this is not an isolated incident. We're talking about child sexual abuse content, illegal drug sales. I mean, it's gone way too far. So I appreciate that you all have proposed some solutions for this. Dr. Citron, you've highlighted a safe harbor that if companies use their best efforts to moderate content, they would have some protection. But how would this work in reality? Would this be then it's left up to the courts and those type of liability lawsuits, which kind of speaks to the need for very clear standards coming out of the Congress, I think?
So yes, it would, and thank you so much for the question. How would we do this? It would be in the courts. So it would be an initial motion to dismiss. The company would then, whoever's being sued, the question would be, are you being reasonable in your content moderation practices writ large? Not with regard to any one piece of content or activity. And it's true that it would then be a forcing mechanism, a 12b6 motion in federal court, to have companies then explain what constitutes reasonableness. Now, I think we can come up right now with all of us. We've come up with some basic sort of threshold, what we think is reasonable content moderation practices, what we might describe as technological due process. Transparency, accountability, right? Clarity on what it is having a process, having clarity about what it is you prohibit. But it's going to have to be case by case, context by context, because what's reasonable response to a deep fake, and I've done a considerable amount of work on deep fakes, is going to be different from the kind of advice I would give to Facebook, Twitter, and others about what constitutes a threat and how one figures that out, how we can use, and I'm going to thinking about Dr. Fareed's testimony about what we do about there are certain issues.
And it would be in the public interest, I believe, that if it is explicit illegal content, that it wouldn't wind up as an issue of a fact in a lawsuit. What do you think, Dr. Fareed? If it is illegal content online, there really shouldn't be a debatable question. Right?
I'm not a lawyer, to be clear. I'm a mathematician by training, so I don't think you really want to be asking me that question. But I completely agree with you. In some cases, what we have seen over the years, and we saw this when we were deploying photo DNA, is the technology companies want to get you muddled up in the gray area. So we had conversations when we were trying to remove child abuse material saying, well, what happens when it's an 18-year-old? What happens when it's not sexually explicit? And my answer is, yes, those are complicated questions, but there's really clear-cut bad behavior. We are doing awful things to kids as young as 2 months old. There is no issue.
I'm going to interrupt you because my time is short and just highlight to the witnesses. There's also an issue with the number of moderators who are being hired to go through this content. A publication called The Verge had a horrendous story of Facebook moderators, and it caught my attention because one of the places is in Tampa, Florida, my district. I'm going to submit follow-up questions about moderators and some standards for that practice as follow-up, and I encourage you to answer and send it back. Thank you.